So hello everyone, my name is Lauren Antone and I'm the Senior Marketing and Events Coordinator at MAR, as well as the producer of our free webinar series. Our webinar today is Realtor Forms, Proper Completion and Avoiding Violations. This webinar will cover how to properly fill out the state and federally mandated forms, such as the Consumer Relationship Disclosure Form, Dual Agency, and Designated Agency Consent Form, a home inspection fact sheet, lead paint property transfer, and tenant and short form vacation rental forms. Avoid possible fines and Chapter 93A consumer protection violations by learning the proper way to complete this paperwork. After our live session, the webinar will be recorded and added to our website at marealtor.com. If you have any questions throughout the session, please type them in the bottom of the chat box on your screen, and we will hold a Q&A afterward. Our presenter today is Andy Consoli. Andy has been teaching real estate and first-time buyer classes for over 25 years. The owner of state license ABC Real Estate Training, Andy is a certified real estate instructor in Massachusetts and New Hampshire. Andy was named 2018 Real Estate Educator of the Year for the North Shore Board of Realtors and has been recognized by the Massachusetts Board of Realtors in 2006, 2007, 2008, 2009, and 2017. In addition to his work as an instructor, Andy is also a licensed real estate broker in Massachusetts and New Hampshire. He's a certified and fully licensed home inspector, construction supervisor, exterminator, air conditioning technician, heating technician, 203K consultant, Title V inspector, home improvement contractor, lead safe renovator, and moderate risk deleter. Now over to Andy.
Okay, you guys, so thanks for coming on board. We have a short time. This is actually a 2-hour course, so we consolidated it a little bit for you, and we'll get the ball rolling. Thank you so much. We have commonly used forms. You guys use these forms all the time. So let's take a look. We have mandatory forms, and one of the big ones, of course, would be the agency disclosure form, which is of course, that comes into play all the time. You guys know that you must present this form at the prior to discussing a specific property in Massachusetts. In New Hampshire, it's a little different. It's the first business meeting, but this is a Massachusetts discussion. If you have any concerns about New Hampshire, you can give me a call and we'll make sure that you get some clarity on that. So prior to the first discussion, we have to present the agency disclosure form, which is called the Consumer Relationship Disclosure Form. But remember, in the old days, it was called agency disclosure form. So if you do not provide that form at the right time, you know that you can be held accountable to those two numbers in one letter that's really bad, the 93 something, 93A. So we must present the form. Does this form look familiar to you? I hope so, because this is the form. We have, it says right on the form, when do you present the form? Well, it says it right there. The time when the real estate licensee must provide this notice to the consumer. So there shouldn't be any confusion, it's right there. But yet, this is a big problem in the real estate industry all over the place. Timing of the form. All real estate licensees must present this form to you at the first personal meeting with you to discuss blah, 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 blah. You're talking about a specific property. In the event this relationship changes, an additional disclosure form must be provided, which confuses people. So if Judy walks into my office, my real estate office, and Judy wants to know what's going on with 85 Elm Street in Amesbury, before I can talk to Judy, I must give her this form. I cannot talk to Judy about that home specifically without the form. Now, I could talk to Judy about the general welfare of real estate in the Amesbury area and how, what the school systems are like, but I cannot specifically discuss that property without giving them this form. And remember, it must be given before you start talking about the property, before. And you can't unring the bell. So that means if you give it at the wrong time, you can't fix that. It's too late and you're going down a really bad road. Now this form is unbelievable. It's filled with so much protection for you guys. Look at what it says here. Consumer information and responsibility. It's giant. It means the consumer is responsible for something. I love that. If you're a buyer or a seller, you can engage a real estate licensee to provide advice, excellent, assistance, and representation to you as your agent. Now, the real estate licensee can represent you as the seller's agent, or represent you as a buyer's agent, or can assist you. See the word assist, not represent. And that would be as a facilitator. Just this topic alone is actually a 2-hour class called agency. And not even a 2-hour, it's actually 6 hours of courses called dual agency, facilitator, and buyer or seller's agency. So I'm going to squeeze it all into a really short period of time. But let's take a look here. Real estate licensee can represent you as the seller's agent, buyer agent, or a facilitator. All right, that's interesting. Now down here it says all real estate licensees, regardless of the working relationship with the consumer, must be honest and accurate. You can't be lying to people. You cannot be engaging in any misrepresentation. Even if these people you're working with are customers, you still have to tell them everything that you're aware of that is material to the property. If you know the roof is leaking, you got to spill the beans. If you know the boiler, you have to tell them. Now that's regardless of your agency relationship. That's what it says over here. You have to treat everybody honest, and you must disclose known material defects. Okay, what excites me the most about this form is the next section. Now it excites me, but it also is problematic for the real estate people. Take a look at it. This is Exhibit A. If you get in trouble and someone says, well, the septic system doesn't work and there's a problem with the termites, this paragraph will set you free. It's huge. The duties of a real estate licensee do not relieve consumers. I love it. It does not relieve consumers. Okay. It does not relieve consumers of the responsibility to protect their own interest. This is huge. If you give them this form and they don't read it, or you don't give them time to digest it, or you forget to give it to them, then they will never read or see this paragraph. This paragraph is big. Okay, so it is their responsibility to protect their own interest. It says to them, hey, dude, if you need advice for legal matters, tax, insurance, zoning, permitted use, like, can this be a laundromat? Can you? No, I don't know. It's up to you. You are the buyer. You figure it out. Or land survey matters. Oh, I thought the lot line was, no. You want to deal with the survey, you want to deal with the land, you deal with it. It is your responsibility, you, the buyer, to consult a professional in those areas. Love it. Real estate licensees do not, this is even better. You do not perform home inspections, lead paint inspections, insect inspections, nor do you perform septic inspections, wetland, or any environmental evaluations. This is huge. When I bring this paragraph up in my agency class, there are many agents who never read it or remember reading it. This is huge. So if someone says to you, I have a radon problem, like, what does that have to do with me? I found you a home. I gave you this form. I gave it to you at the right time. You, I assume, read it, and it says it is your responsibility to check out environmental things. Why didn't you do a radon test? I mean, what do you want me to tell you? So this is huge. Now, you can defeat this whole paragraph. You can really extinguish it on your own, which is bad. you could take away its effectiveness if you start pretending to be these people. Oh, Andy, what will the tax implications be if I buy this property? And you start going, well, you know, if you consider the tax thing and that, if you start giving them tax advice and insurance advice and permitted use advice, then you defeat this whole paragraph, because it's not supposed to be something we're doing. We're supposed to say to them, it says right here, this is your responsibility. Call people and figure it out. Now, do not assume real estate licensees work solely for you unless you have an agreement for that relationship. That's huge too. The buyer can say, well, you know, I thought you were supposed to be representing me. No, I'm not. It says right here, I'm not, unless we agree to represent you. Now, on that agency disclosure form, this is the next section down, right over here. I know you guys have seen this a million times. Most agents, at least, are very familiar with this section, but the paragraph I just read, they don't, you know, they haven't read it too much. It says, the seller or buyer receiving this disclosure is hereby advised that the real estate licensee named below is working as a, you got to check it off. Are you a seller's agent, a buyer's agent, or a facilitator? Well, it depends. If Mary walks into my office, she's a buyer, a prospective buyer, and she wants to know about Elm Street in Amesbury, well, is it my listing? Is it my company's listing? Are we designated agents? Are we dual agents? Is it another company's listing? It really depends. If it's my personal listing, then I would have to say that my relationship with the buyer is that I am a seller's agent. That's my relationship with this Mary who walked into my office. If it's another company's listing, well, I have some options here. I can ask Mary if she wants me to be a buyer's agent. We could fill that out. Or Mary might say, no, I don't want to be represented by you. I don't like you. Well, then I could still show her the house and I would check off facilitator. So you guys got to be careful with facilitator. If you check off facilitator, it means that you have no fiduciary relationship with the buyer or the seller. Remember that. A facilitator cannot, N-O-T, represent anybody in that transaction. So be really careful. Now, if seller or buyer agent is checked above, the real estate licensee must complete the following section. If seller or buyer agent is checked above, then you must identify whether you're a non-designated agency or a designated agency. So it's up to you guys. I mean, I don't know if you're a traditional agency or not. If I've asked people in my class, like, hey, how many of you guys are designated agents? And a lot of people go, I'm not sure. How many of you guys are traditional agents, which is called non-designated? I don't really know. So you have to ask your boss, what are we? And the boss would have to tell you what you are. And if some people say we're a little bit of both, that doesn't exist. Your company has to decide, are you designated or you're traditional? So this form is critical. Make sure you fill it out correctly. Make sure you pass it out to these prospective buyers at the first personal meeting before you discuss the specific property. Make sure you sign it. Put your license number. Keep this in mind. If you're on the telephone at this point in Massachusetts, you do not have to have them sign this before you discuss the property. But in New Hampshire, you do. New Hampshire is a whole different animal. So you people watching now who have a New Hampshire license, agency disclosure forms are totally different. You have to give the form even on a telephone call or on an email. So it's another world. So be really careful and don't use the wrong form in the wrong state. Let's take a look here. Now, this is consent to dual agency. You must give If you're a dual agency company, I don't know if you are or not. So if you're a dual agency company, then you are a traditional real estate firm. So it gets complicated. So I'm just talking about forms now. I can't go into too much depth in as far as agency. It would be here till midnight. So if you're a traditional real estate firm, then you would have consent to dual agency, standalone forms like this, or built right into your buyer agency contracts or your listing contracts. So you would need to get a consent to dual agency document signed, and that would tell the seller or the buyer that at some point in the future you may become a dual agent, and they'll accept it. They find that to be okay. The moment you actually become a dual agent, then you need to give them another form called notice of dual agency. Some of these contracts you guys use, the notice of dual agency is actually built into your contracts. So you would go to those contracts and you would check a proper box. But if you don't have it in your contract, you would have to have a standalone form. And you can get these forms online, and you do have to have them. Now, notice of dual agency. When does dual agency happen? People go, I don't even know, when am I like a dual agent? I know you guys know this. Mary walks into the office. She wants to look at 25 Elm Street. I am, let's see, I will now be her buyer's agent. And I show her Elm Street. Elm Street is listed with another company completely. So I'm her buyer's agent. That's awesome. All of a sudden, Mary, still my buyer's agent, wants to look at 25 Main Street. 25 Main Street is listed by my company, and we are a traditional real estate firm. So since my company represents the seller and my company represents Mary, because we're a dual agency, we're a traditional firm, then I would become a dual agent at that time, and I'd be representing both the buyer and the seller, and I would have to give a notice at that moment. And on the notice, I would have to indicate that right now on Main Street, because it's my company listing, I represent both of you, and I am giving you notice. The dual agency is happening right this split second before your very eyes. It's like magic, like it's happening. There's another form. If you're a designated agency company, and not as many people are that you think. In my classrooms, I have a lot of folks who are still traditional, but Massachusetts consent to designated agency. If you're a designated firm, when you take a listing or you take on a buyer client, you have to get the consent to designated agency form signed. And when designated agency occurs, you need to get a notice signed. Once again, some of these are built into your listing agreements and your buyer agency contracts. If not, you have to get the standalone document. You're a designated agent company. Okay. Mary walks into the office, designated agency company. Mary wants me to be her buyer's agent. That's fine. I'm Mary's buyer's agent. Mary wants to look at another company's listing. Awesome. I'm Mary's buyer's agent. I don't have to give her notice of designated agency because I'm showing her another company's listing. If Mary wants to look at Main Street, which is my company's listing, I can still represent Mary. I will have her fiduciary. Someone else in my office is representing Main Street. The other agent in my office has fiduciary to Main Street. I do not. I have fiduciary to Mary. But my broker has fiduciary to Mary and Main Street. So that means the broker, the company, is now acting as dual agent. So I have to make sure that Mary is given a notice of designated agency, which takes place right now. Notice of designated agency is required when you're showing Mary an in-house listing in a designated agency office. Now, I can go over this for another 25 hours in our agency class someday, but this is a forms class. I want to make sure you know these forms are on the table. They are required, and they're required at a particular time in the transaction. This is another mandatory form. It's called a home inspector fax for consumers. I hope you guys are aware of this, and many of my students go, I don't know what you're talking about. Never heard of this thing. Okay. Home inspector fax for consumers. It's been around for a while. Real estate agents and sellers of unlisted property must provide the fax. Must. That's like a bad word, like must. No, must. Oh, I really have to do this, right? Yeah, you must provide the fax for consumers fact sheet to all buyers before the first contract to purchase, which you guys know is in many parts of Massachusetts, it's called the offer to purchase. Okay, so before the offer to purchase, you must give the fax for consumers, home inspector document. It's 5 pages. Now, where are you going to get this form? Well, hopefully you're giving it already, but if not, you can type, go online and Google, hey, fax, home inspector fax for consumers, and, print it out. It's 5 pages. Now, let me give you a little bit of information here. The law says that buyer agents, if you're an agent and you have fiduciary to the buyer or the seller, you have a fiduciary relationship, then you can directly recommend a home inspector. So you could say, call Andy. Anybody else? No, just Andy. That's the only guy. If you have a fiduciary to your seller and they want to do a pre-inspection, for instance, you can directly recommend a home inspector. Same thing with a buyer client. But if it's a buyer customer, then you're supposed to say, well, there's a list with a bunch of people on it, and go to the website and pick somebody. Now, a lot of real estate agents, they have a whole pile of home inspectors in their office on tables. They have brochures. That's fine too. And you could say to folks, well, since you're my customer, there's a table over there. You can pick whatever you want, but also there's a state website with, everybody's name on it. Now, I would, if I were you, right above that table with all your brochures, you should have a message that says that we at this company do not endorse the quality of the services offered by any of these companies. We're not guaranteeing their work at all. So you could have some kind of a disclaimer that says that they also could go to this website and download all the names if they want. That these brochures are just for convenience only, and you don't authorize and you don't sanction anybody's work. It's a convenience. Now, let's take a look at this form. This is called Fax for Consumers. You have to have it. It's one of those must-have. Look at this. See right over here where it says about the home inspection? This is where you guys can get in a little bit of trouble. See right here? And guess where it's from? See that? Look at that little nice picture. The Commonwealth of Massachusetts, Office of Consumer Affairs, Division of Professional Licensure. So this is real. This is not fantasy. This is real. Right here, let's blow this section right up. Boom. A standard home inspection, right here, is a visual examination of the physical structure in major interior systems of a residential building, consisting of 1 to 4 dwelling units. So if it's a 5 unit, then it's really doesn't fall under home inspection law. There's a new class we teach called Residential Inspections. It's awesome. It's a brand new course, just allowed. We take you on a 2-hour journey of what home inspectors are required to do and what we don't do. But anyway, It says standard home inspection is visual, like eyeballs, of the physical structure and major interior systems, meaning major systems, not like little dings and little stains on carpets. An inspection can be likened to a physical exam by a physician. Okay, by a physician. You know, you go to your regular doctor and they're generalists. They go, oh, you got a big lump in your face. Maybe you need to go to a guy that knows about lumps in faces. So a home inspector is a generalist. He'll point you guys your buyers in the right direction. However, it should be clearly understood, clearly is like, wow, clearly, okay. It should be clearly understood that a home inspection is not to be confused. Don't confuse it as an appraisal. People ask me, what do you think the house is worth? I don't know, I'm not here to do that. A building code, this is the big one. So many realtors go, is that out of code? Is that out of code? I can't answer that because we can't be talking about code. It's prohibited. So I'm not a building code guy. I'm not there for code. Although we do point out a million things that are wrong. And many of those things are code problems, but we can't say it's code. It's just, wrong. We just say that's wrong. Those steps are funny looking. They're sort of wrong, but they out of code. They're sort of just wrong. You can't get into the word code. A guarantee, it's not a guarantee, like of any kind. It's not an insurance policy. Home inspectors aren't insuring anything. Like, they didn't insure anything. And that's what the state says. So when people go, well, you were supposed to like guarantee me that this house was in good shape. Really? That's the opposite of what I'm supposed to do. The state says I'm not there to guarantee you. But anyway, let's take a look. Boom, boom, boom. And that form is 5 pages long. And that's the form you need to give to people. Okay. Now, did you know that they changed the rules on the fee disclosure law? So you don't have to give a fee disclosure anymore unless you plan on collecting a fee from the buyer. Well, from the tenant, the prospective tenant. So if you want to show rental property and you want to charge the tenant some money to hang out with you, to show you properties, you have to fill out a fee disclosure. If you don't plan on being paid by the tenant, then you don't need it anymore. But if you do use it, you have to fill out, make a form, create a form that answers these questions, like how much is the fee? When is the fee due? Is the fee payable even if they don't rent something from me? What's going on? And then you sign it. And that has to be given at the first personal meeting between you, the agent, and the prospective tenant. So if you plan on charging a tenant a fee, you have to give them this form. It would be mandatory for you to be able to enjoy a fee from the tenant. If you don't give it, then hopefully the landlord's going to give you something for your time. This is the hugest of all, lead paint disclosure form. Mandatory, but only if the property is built before 1978. Let me give you this little tip. People tell me, well, how do I know how old it is? Well, what do you think? And they go, well, the occupancy permit. No, not the occupancy permit. It is the building permit. So you go to town hall and you ask, when was the first building permit on this address? And that's the birthday. So if the house was built on December 31st, 1977, you need a lead paint disclosure form. Hey, 24 hours later, you don't. So if it was built, if it had a permit on January 1st, 1978, not only, you guys, do you not use an agency disclosure form, the EPA says if you do use one, they have the right to fine you. You're not supposed to use one. The rule is you only use a lead paint disclosure form on a target property. And a target property is a house built based on the building permit before 1978. And I see so many real estate agents like, well, I still use the form on a 1985 property. Like, no, no, no. Use the form on target properties. Do not use it unless it's a target property. So we have property transfer lead paint notification. That's the most common one you guys are going to use. And then there's a tenant lead paint notification. If you're in the rental world, you know, you can never, ever let a tenant move in. Before the lease is signed with a tenant on a property built before 1978, you must give a tenant form. Short-term vacation rental, Salisbury Beach, third less rental. So if the tenant's moving into a beach house or something like that, and it's 31 days or less, and it can never be more than 31 days within a year. So they can't come back 2 months later. So if they're going to rent short-term vacation rental, 31 days or less in Massachusetts, the real estate agent or landlord, whoever's in charge, must have the tenant sign a short-term vacation rental lead paint disclosure form. And that has to be signed before they sign the short-term rental agreement. If you don't do that, you have a major problem. See, every house in Massachusetts must have a lead certificate if kids under 6 live in it. Every house built before 78 must have a lead certificate if children live in the house. Even owner-occupied property, even houses that are owner-occupied, single-family homes must have a certificate from a lead inspector. The only exception to the rule is a short-term vacation rental. 31 days or less within a year, house built before 78, little kids under 6 can live in that little place on vacation, and that would be fine as long as the place doesn't have peeling paint and, you know, chipping paint. Has to be in, you know, good shape, but it does not need a lead certificate because you signed the waiver. There is a waiver, and that waiver is called the short-term vacation rental lead paint disclosure form. And then, of course, there's contractor renovation lead notification. So anybody working on a home in the United States built before 78, and they're like disturbing things, they're sanding the walls or doing construction, scraping, painting, they would have to give another form called a Renovate Right booklet. They would have to give this to the tenants and the landlord, or everybody's in trouble. So there's another mandatory form for contractors. Now this must look familiar to you, I hope, right? Excellent. It's the property transfer notification certification. Oh, look at this. Property transfer, that must mean you're selling a house. Okay, it's not a rental. Notification, that's good, and certification. Well, where do we go? Hold on, where to go? Where are we? There it is. The notification is the first 10 pages on the front of this document. And the certification would be what you see right here, the last page with the copies. So by law, you must give the prospective purchaser, you must give them this form on all target property. They need to fill it out. You need to file it for 3 years. 3 years. Oh, by the way, agency disclosure forms and all those notices we mentioned, 3 years. 3 years filed. I would file them longer because in Massachusetts, 93A can go after you for 4 years. Then you get the discovery rule aggravation. So somebody can still come after you even beyond the statutes of limitations. So I would store this stuff, you know, for a long time. People ask me, I go, digitize it and keep it forever. So anyway, let's take a look at this form. Boom, let's bang it out. This is a lead paint. This is a 2-hour lead paint course, but I'll break it down in a few minutes. Property transfer notification certification. Would I get those words? I got them right up here. This is the very beginning of the form. Let's blow it up. Boom. This form is to be signed by the prospective purchaser before signing a purchase and sales agreement. or a memorandum of agreement. So many agents say, I don't need to give the buyer this form until we get into the purchase and sales agreement stage. No, you must give them this form at the first contract, which is usually the offer to purchase. The offer to purchase. If you give it to them beyond the first contract, you are in a heap of trouble. Okay, by the lessee purchaser, okay. It says on properties built before 1978, not 1985. For compliance with federal and mass lead laws, you must give this form. And then it says on the form, this is right on the form, I just blew it up. Federal, required federal lead warning statement. Every purchaser of a home built before 78 is now notified. If you have kids under 6, it's bad. They can be poisoned. And then it says lead poisoning may produce permanent neurological damage, including like learning, reduced intelligence, behavior problems, impaired memory. Like what? Lead poisoning also is a risk to pregnant women. Now, those aren't the only scary things. If you read the notification, which is the first 10 pages, oh, it has a lot more. It's loaded with important information. That's why it's required that people be given the notification. And they're not supposed to be like handed it to them and go, oh, just put that away. We don't need it for now. No, they need to read it. Now, take it home, curl up in a chair, and read it. This is what you need to know. The seller of any interest in residential property is required to provide the buyer with information on lead-based paint hazards. So if you listed a home, you got to tell the seller, you go, dude, you have a requirement under the federal and state law to fill out this lead paint disclosure form because it is a target property. And with information, so they fill it out, and let's see, a risk assessment or inspection for lead-based paint is recommended. So if people ask you, what would you do? Well, the form says that the federal government and the state recommends it. Yeah, but what would you do? The state and the federal government recommend a lead inspection. So I would recommend it too. I'm not going to contradict what they're recommending. Now, on the very top of that form, the first section you start filling out, it's the seller. So the listing agent gives the form to the seller. The seller answers some questions. I mean, you could go over it with them, go, hey, Mary Beth, the presence of lead-based paint or lead-based paint hazards, do you know of it? Are you aware of it, or do you have no knowledge? She go, well, I don't really know anything about that. Okay, then why don't we fill out BII? See the B, AB, BI, no, that says she would have known something. BII says she doesn't know anything. Now here's your problem. If you put an initial in this little box, well, that's an $11,000 fine to the real estate agent. Awesome. I'm trying to make some money here, and I already lost 11 grand. And it has to be a check because it says check I or II below. So you go to the seller, put a little check there. Check. Awesome. Check. If the seller has knowledge, they would put a little check here. Check. And then right on this line, see there's a line here? It says explain. So you'd have to have the seller. It's like, Mary Ellen, why do you know there's lead-based paint like going on here? Well, because I had a lead inspection a couple years ago when I bought the house, and the guy told me, like, okay, let's write it down. Had lead inspection couple years ago. Lead inspector told me we have some lead in the house. There you go. Excellent. Don't have to write a whole story. And then over here, it says, well, if Mary knows about lead, check. She wrote down, had lead inspection. Awesome. Then it says, seller has provided the purchaser with all available records and reports pertaining to the lead. Mary Ellen, I'm your agent. That's me again. Focus. Do you have that lead inspection that you claimed that you got a couple of years ago? Oh yeah, it's up here in the bedroom. Okay, go get it. Oh, Mary has the records. The real estate agent better go back to the office and make copies of those records and bring Mary the originals. Don't lose the originals. Don't lose the originals. You're in big trouble if you lose the originals. Get Mary the originals back. You keep the copies. And then look at this. Seller has provided purchaser with available records with the copies that the agent made. Mary, put a little check mark here. Awesome. Lead-based paint hazards. It says circle documents below. See this? Lead-based paint. What documents does Mary have that you made copies of? You said a lead inspection report. So circle lead inspection report. Now, some forms you guys are using have a little checkbox in front of each one of these, and it'll actually say check the box. Some forms say circle the document. Whatever your form says, you do it. If you forget to do explain, 11 grand. If you forget to circle the document, just another 11 grand. If the seller has no reports or records, they have knowledge, but they lost the records. Okay. So they have no reports, so there's nothing to circle. So they would, boom, I don't have any reports. Sorry, can't help you. But I do know that there was lead here. Someone told me. Now, once that's filled out, the listing agent, you guys usually, post it so that the buyer, the agent working with the buyer has access to it. So make sure it's readily available for your, upload it. So the buyer's agent can work with it. So the agent is now showing your listing. The buyer of the co-broke is interested in your listing. You filled out the lead form with Mary Ellen. That form better be available so that the buyer can complete it. It's not finished yet. It's not finished. It's only half finished. So that same form has to now be given to the buyer, the potential buyer, and that prospective buyer would finish it. It's the same form. You can't use a different form. That's illegal. Same form. You could use a copy of the same form, but it has to be the one Mary already filled out. And then the buyer working with the agent working with the buyer, they fill this out. C, purchaser received copies of those documents circled above. Hey, Joe, did you get copies? I just handed it to you. Look at them. Those are copies. So Joe, I need you to initial right over here that you received them. Joe might say, no, I never got them. You're a liar. I don't have them. I didn't get them. I don't have them. Nobody gave them to me. Well, then I guess you better initial right here where it says you didn't get any. And then E, don't forget E. E's huge, huge. Make sure that they initial that they received the property transfer notification, which is the first 10 pages. Give it to them. Give them the 10 pages. And make sure that they got the 10 pages. And then over here, make sure the purchaser checks right over here. They're gonna, like it says check, it says initial. Hey, if you put an initial here instead of a check, no, right over here. Right, if you put an initial here instead of a check right here, you got a problem. This is supposed to be initialed. These are supposed to be checked. If you put initials instead, that's another 11,000. It's like, what? Who came up with that? That's the way it is. So over here, check I or I below. Boom. Did they receive do you want to do a lead inspection or not? They should. It really should. You know why? Because a few minutes ago I said, what does the federal government and the state recommend? To do a lead inspection. So they should be doing it. Many times they don't, and I don't know why, because they have to have a lead certified home within 90 days from the day that they move into the house if they have a kid. So why wouldn't they want to know what it's going to cost? I don't get it. But anyway, so let's say hopefully they want to do an inspection. We're almost there. And this is giant for you guys. See this? Agent, this is for you. This gets real scary because this is where you put your pen to the paper. The agent, you're acknowledging that you inform the seller. So this is Mary Ellen, the people working with the seller. So the broker working with the seller, they have to have the seller fill out the top part. They leave the middle alone. That's for the buyer. And then they come down here and you initial that you inform the seller that they are obligated to follow through with this lead paint notification form. See where it says they're obligated, that you explain their obligations? I'll tell you what they are right now really fast. The seller's obligated to fill out this form correctly, no lying, correctly. They're also required to not interfere with a buyer who wants to do a lead inspection. Don't interfere. If the buyer wants it, don't say no. You can't say no. And the third is never discriminate on an offer to purchase with a lead paint contingency. If a seller is rejecting me because I'm the buyer, I want to do a lead inspection, and they say, no, I don't want to sell it to you because you're insisting on a lead inspection, that is against the law. So you tell them you cannot reject, sellers today are rejecting home inspections. That's okay. They don't have to do one. But they must not interfere with a lead inspection. Keep this in mind right now, because a lot of this home inspection stuff is being waived right now, but they cannot waive, the seller cannot interfere with someone that wants to do a lead inspection. Be really careful with this right now. So they've informed the seller, stay out of the way. And then the seller, the real estate agent with the seller initials. And then we're just about there. This is really important. The agent with the buyer now. So y'all with the buyer. Buyer's all like, oh my God, I'm so excited. This is cool, awesome. You got to go listen. Put your phone down, Mr. Seller. Mrs. Seller, put it down. Pay attention to me now. I am verbally telling you because the law requires my lips are flapping, my tongue's flying. So I'm the agent and I'm verbally telling you, I'm informing you that this property could be dangerous. It could have dangerous levels of lead in the paint, the plaster, the putty, and other structural materials. And I'm telling you now, Mr. and Mrs. Buyer, that it is your obligation to bring the house into compliance under the Massachusetts law by getting it de-leaded or bringing it under some interim control, which is another way of saying de-leading, if it was built before 1978 and you have a kid living in it. I'm telling you, you have to do it. So I don't know why you waived the lead inspection when you have to do it if you have kids under 6. And you might want to know what this is going to cost because it's not cheap. Now, look at this. I verbally told them that they have to comply with lead law if they have a kid under 6, which if they do, then they're the perfect candidate. They have to comply, even if it's a single family. See the verbal? Blah, 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 verbal. There's something else that's verbal too. It's right here. It's the very front page of the notification. Second paragraph down. It says the real estate agent must, M-U-S-T, also tell, lips flying, tongues flapping. You must also tell the purchaser that if a child under 6 years old is going to live in this house, the new owners must have the home brought under lead paint compliance within 90 days of the closing. Must. So that's what puzzles me. Why would they waive a lead inspection when they must have a lead certified home within 90 days? And some of these houses can cost $50,000, $60,000, if not more, to get a lead certificate. So on the 91st day, they are breaking the law, which is criminal and civil. So it puzzles me sometimes, why wouldn't you be doing a lead inspection? It's an old house. You have children. What the heck's going on? Maybe you never read the form, or maybe it wasn't explained to you the way it's supposed to. And when their baby's poisoned, maybe they're going to call a lawyer. So you got to be really careful here. Any questions?
Well, thank you, Andy. That was a very informative presentation. We do have a lot of questions. So let's start here. Does a personal meeting include email or telecommunication, or just a face-to-face in-person meeting?
In Massachusetts, face-to-face right now, but in New Hampshire, whole different ballgame. Telephone, electronic, digital communication, you must give a form. Massachusetts, face-to-face, where you can touch the people. but don't touch people face to face.
Now, what if someone calls you on the phone to discuss a specific property?
Not face to face. In Massachusetts, you can discuss it. In New Hampshire, you cannot. So that is true.
Oh, I think that's
I said that because many students who come into these classes have a double license. So I just don't want them to mess up. Be careful. Two different rules. So Massachusetts, no, it's on the phone. Let me give you a little caveat. Some office policies, when I talk to the brokers, their office policy goes above and beyond the Massachusetts regulation, and they require on the phone to give it. So your office may require it. You should ask your boss, but the law at this point does not require a form on the telephone.
Do we have to sign a buyer's agency agreement to check buyer's agent on the form?
Do you have to sign a buyer agency agreement?
Mm-hmm.
Here's another thing. If you are a realtor, you must have a buyer agency contract, a real literal paper on pen contract, and then you're a buyer's agent. If you just check off buyer agent without a contract, you're in violation of Article 9 of the National Association of Realtors Code of Ethics. So I assume most of you are realtors, but if you're not a realtor in Massachusetts, then you do not need a written contract to be a buyer's agent, so you could check it off. In New Hampshire, absolutely not. You have to have a contract. So I assume everybody here, Lauren, is a realtor, right? They're members of the group.
Yes, they're all members.
Okay. So because you're a realtor, you need a contract to be a buyer's agent, and then you would have the right to check off buyer agent.
The next question, if you do not have a contract with the consumer, can you still be a buyer's agent?
No. Well, if you're a realtor, you'd be in violation of the Code of Ethics. If you don't care about a violation of the Code of Ethics, then you could, because the state law doesn't require a written contract to represent a buyer in Massachusetts. So the state law is going to leave you alone, but the Code of Ethics is going to give you a problem. And that can be a fine of up to $15,000. So I wouldn't do it.
If you're a list agent, can you act as a facilitator for buyer versus dual agent?
No. If you're a listing agent, you cannot represent your seller as a facilitator. Well, there are ways around it, but if you're going to represent a buyer and if you're going to represent a seller with a fiduciary duty, then you're a seller's agent. You cannot be a facilitator. You can't. A facilitator has no representation for anyone. They don't have any fiduciary duty, period, to both sides.
What's the difference between a buyer client and a buyer customer?
A buyer client is a buyer you have fiduciary duty with. Hopefully you have a written contract with them. A buyer customer is someone you have no fiduciary duty. There is no contract. They are a free agent. They can do whatever they want, the buyer. And you have not elevated your responsibility to fiduciary. You're just showing them houses. The buyer is representing themselves, and they are in control of their own destiny. You're not there to be babysitting them, but you must respect your buyer customer by at least disclosing all material defects that you were aware of and be honest with them. But you don't owe them a fiduciary duty. Loyalty, obedience, confidentiality, accountability. You don't owe them any of that. So it's a giant difference. It's night and day. It's like between a dog and an orange. Two totally different things. And they have to be treated the right way.
So someone's having trouble understanding when, as a buyer's agent, we can recommend one inspector as opposed to giving a list.
Sure. The law was carved out. It says, listen, if you have a fiduciary duty with your buyer client, then we're going to allow you to directly recommend a home inspector. If you feel strongly about a home inspector, that they will do a good job for your buyer, then you have the right under the home inspection law and under the real estate law that combine together to create this rule. You have the right to directly recommend because of the fiduciary duty. You're supposed to take care of these people. And if you think it would be wise to point them in the direction of a very experienced, qualified home inspector for their own good, you have the right to do that. If they are your customer, you don't. You're not there to look out for their best interest. You're not there. You're there to be honest and disclose material defects, not to babysit. So you cannot be directly recommending a specific home inspector. You would just tell them there's a whole bunch of them and to pick one out. You could say there's a brochure rack over there. We're not endorsing anybody, but that might give you a head start. It's just the regulation. And a lot of people, they get that. Some people, still don't want to recommend anyone, and that's up to them. But your buyer can come after you and say, because you didn't recommend a good home inspector, I used a bonehead. And that bonehead made a lot of mistakes. So since you were my fiduciary, I was hoping that you would give me some advice, and I wouldn't be in this kind of trouble right now if you stepped up to the plate and recommended a good person. So you have the right to do it.
Do rental prospects in New Hampshire need an agency disclosure?
Yes. In New Hampshire, agency disclosure is required for rental prospects, but in Massachusetts, it is not.
Sorry, I'm just reading through some questions here. One of them says, home inspector fact sheet slide says for unlisted property, question mark. I don't know if that makes sense. Sharif, you want to elaborate on that question? What about zip logics and DocuSign systems using X's, not check marks?
Okay, so the EPA worked that out, and they said that at one time, if it said check, you use a check. But since so many people put a little X, they are now saying an X and a check will be the same thing. What I would tell you to do is use a check. If you make a mistake and use like a little X instead, they're going to leave you alone because they realize that it's confusing. But I'm telling you now, it would be best to use a check, because some of these inspectors for the state, for the federal government, for the EPA, they don't care about anything other than the facts that it says check, and they can still give you grief. And if you do get in trouble, you'll win. But I don't want you to get in trouble in the first place. So just put a check. If you put an X, you're going to be fine, but you're going to have to jump through some hoops if you have a difficult inspector reviewing your documents. Hey, remember, one company in Massachusetts got hit with $102,000 in fines just a few years ago for filling out lead paint disclosure forms incorrectly. So it's real. The EPA came to their office, they looked at their lead forms, they added up all the defects and the mistakes, and they came up to 102,000. So it's real. Be real careful. Do exactly what the form tells you to do.
Now, on the lead inspection form, can you repeat whether buyer's initials or they check line F?
Lead inspection form. A, B, C, D, E, F, right?
Mm-hmm.
Right over there, they're still in the initial world, because it says here, check I or II below. Then you jump to the checking. Up here, you're in the initial world. You guys see it on the board?
Mm-hmm.
And down here, you're in the checking world.
Someone is asking about home inspections. They say the seller can object and not allow a property home inspection. I didn't think that was allowed.
Absolutely. A home inspection is not something that they legally have the right to ask for. It's a contingency in the offer to purchase. So when you present the offer to purchase to the seller will go, well, I don't mind the price they're offering, but I don't want to do a home inspection. And they'll go, give them a counter. Let's counter back. I'll accept everything, but I will not allow a home inspection. That's fine. They can reject any kind of inspection except a lead inspection.
Isn't the seller responsible for the cost of de-leading?
No, not at all. When a buyer moves in, the buyer will have to de-lead that home if they have children under the age of 6 at the buyer's expense. This is why you want to do a lead inspection before you buy a house, at the offer to purchase stage, get an estimate. Have a lead inspection, get an estimate. If it's 30, 40, 50 grand, you might want to negotiate with the seller to help pay for some of it. In today's real estate market, you're getting nowhere. The sellers run the show. But in other markets, when it's a buyer's market, you might have a leg to stand on if you have an estimate that is beyond what you're willing to deal with over the next 90 days. And you can get some assistance from the seller. Totally negotiable.
Should we have the buyer initial the 10 pages of the lead law that they read it?
It's okay if you have them initial the 10 pages. It's unnecessary because right over here, it says, see the E? Purchaser, unless the purchaser has received 10 pages. That's what it says. So if they initial this and then they sign at the very bottom, it says right here, certification of accuracy. If the following parties have reviewed the information above, awesome, and certified to the best of their knowledge that the information they have provided is true and accurate, which means when the buyer signs this, they agree that everything above is okay, and they wouldn't have signed it otherwise. So there's something called the law of presumption in the lead world. So if this over here, purchaser, right over here, if it says that they've received the 10 pages and at the bottom they sign everything's hunky-dory, you're good. Do you want to have them initial those 10 pages? Absolutely, you can do it. But when it comes to this certificate at the end, don't alter it. Do not alter a certificate at all. Do not alter a certificate. But the first 10 pages is just boilerplate documentation called a notification. You can initial those, and why not?
If the buyers do not have kids at the time of the transaction, what should we be telling them about lead paint tests and the law?
I'll tell you, the weird thing is, you know, those first 10 pages I talk about, the notification, it explains in that document, the 10 pages, that if the buyer moves in without a kid and decides to have one in the future, it tells them exactly what's going to happen. And I'll tell you what it is. They buy the house. They don't do a lead inspection because they have no children. That's okay. 2 years later, they have a baby living in the house. That homeowner is breaking the law, criminal and civil. It's illegal. It's against the law 2 years later to have a baby living in that house. It's against the law. There is no more 90 days. The 90 days is only from the day you buy the house that you're exempt from what is called strict liability. So 2 years later, you have a baby. Hey, you have a baby. Awesome. Babies are fun. Babies are fun. But before that baby came home from the hospital, the homeowner was required by the law to have the house lead certified, de-leaded. And apparently they most often don't do that because they don't know that they need to. But guess how they would have known they need to? If they read the notification. So what does a realtor say to these people? Get a lead inspection and ask the lead inspector all these questions. They're an expert at this. What are you asking me for? My job is to give you the form. I'm not a lead expert. I never went to lead school. So I'm not getting into lead law with you. I went to a 20-minute class on lead. I'm not qualified. But I just told you the answer. The answer is they will have to have it lead certified.
When we do a listing appointment, do we check the box for seller's agent or facilitator?
When you do a listing appointment, okay, this is fun too. The minute you go to a listing, you knock on the door at 25 Adams Avenue. Hello, Mary Jo. I can't say Mary Jo, that's confusing. Hello, Tony. You asked me to come and take a look at your house. You're thinking of selling it. Oh, yes, thanks. Come on in. Tony, can you show me around? You just broke the law, you guys. You cannot be having a discussion about this specific home right now without having Tony sign the agency disclosure form. Now, if Tony's going to hire you as his fiduciary, because he really wants only you, he's not even asking other agents to look at the house. He's going to hire you right now, today. Then you can check off seller's agent. If Tony is unsure as to who he's hiring, then you would check off facilitator. When you leave that afternoon, 2 hours later, you go, Tony, it was fun. Awesome. I love your house. I hope you call me. I hope you list with me. When you leave, you file that form for 3 solid years, and you were a facilitator for a little while at that home. If Tony calls you back the next morning, I want you to list it. You fill out another form, an entirely new form, and you check off seller's agent, and you fill that one out.
When a buyer asks how anyone will know if you deled, what do you tell them?
A buyer asks if anyone will know. Say it again.
Right. When buyer asks how will anyone know if you deled, what do you tell them?
If you deled, how will anyone know if you deled?
Mm-hmm.
A buyer, who's gonna deled? The buyer?
I'm not sure. Nancy, do you mind expanding on your question for us? And I'll get back to you. Let's see what's next.
Or does she mean inspect, not deled? Does she mean who's going to know that you inspect? I don't know what she means. Let's clear it up.
Yeah, Nancy, get back to us on that and we will answer your question. What is the fine if an owner-occupied house doesn't get deled test within 90 days?
Oh, the if you have a child in the home on the 91st day and it's a target property, it's criminal and civil. And people ask me, how am I going to get caught? Well, every child has to be blood tested from 9 months to 4 years old in Massachusetts. That's the minimum annual, from 9 months to 4 years old. The pediatrician is going to find an elevated level that exceeds 10 micrograms per deciliter. And once you hit 10, it used to be 25 micrograms, but they just lowered it to 10. So once the kid reaches 10, they're lead poisoned. And that's going to be like, kids are getting lead poisoned easier today because they lowered the threshold from 25 to 10. So this is what's going to happen. It's going to be the 91st day. And from that point forward, we got a problem. Pediatrician does a little blood test, which is mandatory. The kid has an elevated level of 10 or above. The pediatrician childhood lead poisoning prevention program. You get a certified letter in the mail that says, and you need to have this house lead certified now. And get a D letter, get it done, and you can't believe that you now have to spend $50,000 that you didn't anticipate, or you have to move into a different house that doesn't have a lead problem, and the state will not let you go. They will not drop the ball. So you're in a heap of trouble. A family in Lexington, if you look it up, they refused to do it, and the state finally said, okay, you keep playing the game, we're going to hold you accountable criminally, and we're going to put you and your wife in jail. So that's what's going to happen if you get caught. And will you get caught? Oh yeah, the pediatrician will catch you. And you also get caught in a divorce. When you're getting divorced, the husband might say, this kid's not staying in this house. This house is not lead certified. He's going to move in with me. And it becomes a whole custody thing. Very careful.
So if
and it all happened because the real estate agent didn't explain the document very well. Okay, go ahead.
Sorry. So if we're a realtor and don't have a buyer contract signed yet, how do we complete the agency disclosure?
If you're a realtor and you don't have the buyer agency contract signed yet, right?
Yep.
Well, when are you supposed to say that one more time?
So if we're a realtor and don't have a buyer contract signed yet, how do we complete the agency disclosure?
Okay, so you can't be a buyer's agent. So you have to check off that if you would be a facilitator, because you're not representing the buyer. You're a facilitator. If you really want to be a buyer's agent, give them a contract. Check off buyer agency and make them sign the contract. And you're good. Realtors will be happy with you. You're in compliance with the Code of Ethics.
Some of these questions are a little bit difficult. If you guys don't mind expanding on, because some of you guys are asking about, like, there's one, Eva, you said in D, do you initial if there's nothing in part B? Can you expand on which form you're referring to?
D.
Can you circulate the proper buyer's agent contract form?
Can you circulate? Oh, you mean me?
Mm, yeah, I got it. I don't really know what that means either.
Okay. A proper buyer, your broker has access to the forms programs, and you have there isn't just one buyer agency contract. There are so many, and you pick and choose which one you and your attorney feels would be the best one to reduce your risk at your company. There's not one, one fits all. You can get some boilerplate buyer agency contracts, but you really need to tweak it, and your company attorney, along with the broker, will create a good one that everybody can live with.
Yeah, it looks like a lot of these questions are on agency. So if they're just our customer, how do we fill out the agency disclosure form? Since you said that we need a buyer's contract to be able to check off buyer's agent, we would, we would just be facilitators then? Question mark.
Yeah, you're in violation of the code of ethics if you check off buyer's agent on this form. I don't know if they can still see the forms. Can they see what I have?
Yes.
If you check off buyer agency and you're a realtor, but you don't have a contract, then you're in violation of Article 9 of the Code of Ethics. So get a contract. Go talk to your broker later today and go, I was at this class with Andy, and where are our contracts? And you can have a one-page simple one or a big 20-page one if you want. But yeah, if you check this off in New Hampshire, you're in real trouble because you need a contract. That's even the law, not just the code. But in Mass, if you're a realtor, you don't need to be in violation of the code. That's unacceptable. So what would you do? You'd be a facilitator. Unless it's your own company, unless it's your own personal listing, then you'd be a seller's agent. That's why the New Hampshire form's awesome, because it just says, right now, you're a nobody, and we'll have to discuss what you want to be. Two different animals. Go ahead.
Does first person meeting include video calls?
No, right now, that's up in the air. It's first physical, face-to-face, first meeting. And right now, there's nothing that has presented itself to indicate that that would be required because it's still in the digital world. So that is probably going to flip at any time. So this is why many companies have decided as office policy, even in a virtual world or on the phone, what we do is send them a digital version of the agency disclosure form and have them sign it digitally. Because you guys have all those dot loops and everything now. So because of the gray area, many policies are like, no, I'd really like you to sign it before we discuss it. And many of you guys have offices in New Hampshire as well as Mass. In New Hampshire, has to do it anyway, so they're already set up for it, and they just like to keep it the same. But so yeah, the answer is no. It's still not a face-to-face meeting, but it's problematic right now with all what's going on.
I'm a licensed agent in Mass. If I am buying a property directly from a seller and not acting as an agent, am I required to fill out agency disclosure form? And what about filling out agent section of lead paint forms?
Okay, so you're a buyer without a real estate agent? Is that what she said?
She said, I am a licensed agent in Mass if I'm buying a property directly from a seller and not acting as an agent.
And the seller did not list it. It's not listed. It's for sale by owner. Then you do not need an agency disclosure form. Nope, not at all. And what was the next part of the question?
Let's see. What about filling out agent section of lead paint forms?
Nope, not at all. It's a private thing. The seller fills out the form, and they're going to probably do it wrong because they don't have an agent helping them. They're trying to do this on their own, which is stupid. So the seller is still legally responsible to fill the form out, and they botch it when it's a FSBO. But the seller is supposed to hand it to you, the buyer, and the buyer in a FSBO deal is supposed to answer the questions at the bottom, and that's it. There's no real estate agent representation. It's just from the seller to you. So the form does have some empty spaces when it comes to a for sale by owner deal. Now you're a real estate agent, so you can give them guidance if you want, but you don't really have to.
If the
But
seller
no,
refuses to sign the mandatory agency at the listing appointment, do you check that they refuse to sign?
oh yes, you have to. So if the seller's refusing to sign, which they don't have to sign this thing, then there's a checkbox that says seller refuses to sign, and that's what exactly what you do. Or the buyer refuses to sign. As long as you present it, you can lead the horse to water, but if you can't make them sign, then you can check off, I tried, but they won't do it. But make sure you still do the form and you file it for 3 years. Yes, that's a good one.
How does one prove that a seller rejected an offer because of lead inspection contingency?
If the seller rejected it because of a lead, how do you prove it?
Mhm.
If the seller, it's going to be testimony. If the seller says to the agent, I'm not accepting this deal because of the lead contingency, the agent is supposed to turn them in. The fair housing law says the agent is actually supposed to say, listen, I'm going to give you one opportunity to not do that again. I'm going to tell you, you're not supposed to discriminate against the lead paint contingency in an offer to purchase. I'll give you a warning. This is the agent telling their own client, I'm warning you, don't do this again. If the seller still says, no, I'm not going to take it because of the lead contingency, you are now required to turn them in, or you're an accessory to that violation, and you get yourself in a heap of trouble. So I'm telling you guys, if you're the agent working with a stubborn seller who wants to break the law, you cannot work with someone who breaks the law. You call your broker and you tell them what's going on, and your broker will call counsel, and counsel will most likely say, disavow yourself from that person. That person's going to get you into a heap of trouble. Think about this. What if the seller says, I'm not selling that house to a woman. I don't like the fact that she's a woman. I'm not going to sell it to her. You could say, don't you ever do that again. I'm going to give you one shot. Don't do that again. And if they say to you the second time, I told you, because it's a woman, I'm not selling it to her. Now it's the same ball game. You don't want to work with someone who breaks fair housing laws, and you walk away and you disavow, and you have your broker and the broker's attorney find a way to sever your relationship, and you walk away. That's how it's supposed to go down, you guys. You're an accessory to a criminal act if you do not turn them in. And you can warn them ahead of time, I am going to turn you in if you ever do that again.
Does the seller agent have to provide the property transfer of lead paint, the 10 pages, or does the buyer's agent do that?
The law, the EPA, holds them both accountable. So if the buyer, say the 10 pages, if the seller doesn't really need to read the 10 pages, they just need to fill out the certificate at the end. So if the agent with the buyer fails to give them those 10 pages, the listing agent's on the hook equal to the mistake of the buyer agent. This is how the EPA plays this game. They're holding the seller agent and the buyer agent, the agent working with both parties, accountable to any mistake on this form. And a mistake would be failing to give the 10 pages. Because didn't you say you gave them the notification? So if the agent initials that they have been given the notification, you better give them the notification. But I just want you to be careful. If the buyer agent is a bonehead and they don't do it, the listing agent is also on the hook. So, hey, maybe it wouldn't hurt as the listing agent to say to the co-bro, the selling agent, did you give them the booklet? Did you give them the 10 pages? I want to make sure you did, because I don't trust you anymore. We've had trouble with you before, and I want to double check it. Or even email them. Did you absolutely give them the 10 pages? Respond, and then file that email. Thank you.
Could you share section of COE that references requirement of buyer agency agreement?
Oh yeah, it's on the code of ethics. Absolutely. Hold on for 1 second, right there.
Mhm.
Yeah, the code of ethics, fun one. Just did the code of ethics the other day. And yep, give me another question too while you're
Yeah, there are so many questions, you guys. I am very happy that everyone is so invested in this webinar and that I want to try and get as many questions as I can in here.
Of course.
I'm a seller's agent. An unrepresented person asks to see the property. Are they a customer and do I need to have them sign an agency form?
Okay, say that one more time. I was looking up the code. Article 9 of the Code of Ethics is right there. So any of you guys can go right to the Code of Ethics. And for the protection of all parties, realtors and realtors shall use reasonable care to ensure that documents pertaining to purchase, sale, or lease of real estate are kept current through, okay, that's the next one down here. Let's see, contract, listing, leases. Let me hold up the right one for you. Give me the next question.
I'm a seller's agent. An unrepresented person asked to see the property. Are they a customer and do I need to have them sign an agency form?
Do they have to have who sign an agency form?
An unrepresented person asked to see the property.
Absolutely. So if somebody walks into your office and they just want to look at a house and they don't want you to be their fiduciary, it's against the law for you to discuss that property unless you have them sign an agency disclosure form. And you would check off facilitator, unless it was an in-house listing or your listing, and then you would check off seller's agent. But you have to give them one, absolutely. I got to highlight it on the very top, Article 9. So you guys can look up Article 9 and you will see that it says right here, realtors, for the protection of all parties, shall ensure whenever possible that all agreements related to real estate transactions, including but not limited to listing, representation agreements, and leases are in writing in clear and understandable language expressing the specific terms, conditions, and obligations of the commitments of the parties, and a copy of each agreement shall be furnished to each party to such agreement upon the signing of that document. So it's Article 9 of the code. Anybody can type Article 9 on Google, National Association of Realtors, Article 9, and read it. And it says it right there.
Okay, so should we post the 10 pages on the MLS as an attachment to protect ourselves?
Yes, definitely do that.
Okay. Would a private seller be subject to the hefty fines for not filling out the lead document correctly? Or are
No,
those fines reserved only for realtors and agencies?
realtors and agents.
Okay. Do you need an agent disclosure form for an unrepresented buyer who attends an open house?
Agency disclosure form. If you have the tent card that you stand up on the table that says, I represent the seller, I have a fiduciary with the seller, then that's an exception to the rule. You do not need an agency disclosure form when you put the tent card up that says you represent the seller. Problem is, if your buyer hates the house at the open house, they walk in, they go, this house is stupid, I hate it. Do you have any other houses I may be interested in? And the agent at the open house says, sure I do. I have a house across the street that you would love. Let's talk about it. That's illegal. You cannot talk about another house without an agency disclosure form. You can talk about the open house without one because you have the tent card up. But other than that, you can't. One more reason why at an open house you would have to give an agency disclosure form. One reason is you're talking about another house. The second reason is your buyer wants to make an offer on the property. If they want to offer on the property, you now fill out an agency disclosure form along with the offer. Other than that, you don't need one because you have the tent card.
If I am the listing agent and have a tent card at the house, if I bring in a customer, if I bring in a customer, does the tent card suffice, or do I need to present a disclosure form?
No, the tent card still is fine. There's an exception to the agency disclosure law. The tent card, as long as it's the right tent card, there are tent cards for designated agents. There are tent cards for non-designated agents, and there are tent cards for facilitators. So if you're at the open house as a facilitator, you need a very specific card that says, I am a facilitator at this house, and I don't represent the seller, and I represent no one at this point.
Okay, we have time
So,
for one more question.
so be
Sorry.
careful. But yeah, no, you're exempt if you have a good tent card. Go ahead.
Okay. Do you know what this person is referring to? Because I had a couple people ask this. In D, would you initial if in paragraph above B, there is no report or paperwork?
Okay, in D. Say
Would
that
you-
again so we can look at the right page. You
It's
looking at the page I have up?
referring to D and B. I've had a lot of questions about D and B.
A, B, C, D, and they're going
Okay.
from D to B. Okay.
Okay, it says, in D, would you initial if in paragraph above B, there is no report or paperwork?
Okay, so paragraph above B. Above B, let's see. I'm going above. Oh, get rid of that here for a second. I'm going above to B right now. And B is they know they have lead-based paint hazards. I assume that's the one they're talking about because that's the B.
I
So-
think so.
So read it to me again and let's follow it along.
Sorry, it's a little bit
Not at all.
confusing.
Let's look at B. What's it say?
It says in D, as in dog, would you initial if in paragraph above B there is no report or paperwork? So go back to that other page that
Let's
you
go to
had.
D then. The purchaser has received no documents in D.
Mhm.
If there are no documents circled above, there's no document. The seller might have knowledge, but they don't have documents. Seller has no documents or records. See, the seller can have no knowledge and no documents, or the seller can have knowledge and also have no documents. So if the seller has no documents, whether they have knowledge or not, there are no documents. So when we get to the next section, which is down here, did you receive copies of documents that were circled? No, I don't have any. There was no documents circled or documents attached. So you would then make sure that you initialed D. Purchaser has received no documents. And I'm telling you one thing, you guys are going to be confused. Because if you are a multi-state agent, New Hampshire and Mass, in New Hampshire, it's filled out differently. In New Hampshire, it says purchaser received copies of information above. And in New Hampshire, you have to make sure you initial C and D every time. Every time. But in Mass, you pick and choose which one applies. So I know why it's confusing, you guys. Anybody who has a New Hampshire license or went to a New Hampshire course on lead, you are confused, or a Connecticut course, you are confused because you're looking at a federal form, which is a totally different animal. In Massachusetts, you pick and choose. It's very simple. Look above. If you have no documents at all that are attached, then you go with the D. If you have documents and you receive them, you go with the C.
Okay. I want to say thank you so much to everyone for all of your awesome questions. I'm so happy that there are still so many of you online, even after, going 30 minutes over. But it looks like that's all the questions that we can answer for today. I hope I got through as many as I possibly could with you all. As a reminder to everyone, this webinar has been recorded and it'll be available to view in the next couple of days on our website at marealtor.com. You can also find it on our YouTube page. Thank you so much, Andy, for your presentation. It was awesome. And thank you to everyone for joining today. We hope to see you next time.
Thanks, everybody.